Good afternoon, everybody, and welcome to today's Open to Export Brexit Q&A. My name is William Barnes-Graham, and I'm a Senior Content Editor at the Institute of Export and International Trade. Open to Export is a free online service helping small businesses get ready to sell overseas through our step-by-step articles and guides, regular webinars, our Export Action Plan tool, and our quarterly competitions. You can find out about all of these on our website at www.opentoexport.com. Open to Export is powered by the Institute of Export and International Trade, the UK's professional body for traders. Endorsed by the World Trade Organization and the International Chamber of Commerce as a small business champion, we offer a unique range of individual and business membership benefits, education and training catering for beginners through to master's degrees, and an always exciting and prestigious program of events celebrating UK businesses' exporting achievements. Now, today's session is all about answering some of your questions about Brexit. We've had a fair few sent in advance, but you can ask questions during the session at any point using the question box on the control panel to the right-hand side of your screen. The general principle here is that we'll ask questions that are relevant to the broader audience, so we won't be able to go into company specifics as such, but if you have specific questions, we can refer you to the Institute's technical helpline. So to set a bit of context and quickly discuss some of the Institute's Brexit support before we dive into the Q&A itself, I'd like to hand over to our Director of Stakeholder Engagement, Kevin Shakespeare.
Hello, good afternoon, everybody. It's a pleasure to be involved with this webinar today. I'm from the Institute of Export and International Trade, and I have a few slides now to talk through some Brexit issues and obviously the Institute's involvement in those issues before we start the Q&A session. So in terms of the slide in front, the European Union remains the UK's largest trading partner. And clearly in some sectors there is a reliance or a huge impact in terms of UK exports to the European Union. So as has been fairly well detailed in some of our press coverage, automotive and cars is a key export from the UK to the European Union. And it's also important to mention that effect that it obviously impacts some of the big car and automotive manufacturers, but also impacts the supply chain as well. So suppliers to the automotive sector and also services and companies that benefit from trading with automotive companies. Clearly the UK leading export product, United States, is pharmaceuticals, but the UK exports more pharmaceuticals, drugs, healthcare to the European Union. So again, another key sector, as is the aviation aircraft industry as well. And again, it's very much about the whole supply chain and not just the lead sellers to European buyers. And interestingly enough, organic chemicals is the only product sector where the US is a larger market than the European Union. And you can see on this slide a high number of different products where there's a big reliance and big impact from UK exports to the European Union. The slide in front of you is obviously a picture of a train, but it just shows how integrated international supply chains are. And it also indicates the sheer level of partners that are actually required in production. And you can see on screen a high number of companies that are referred to in the lines that are providing different component parts of the actual train. So again, it's not just about the end product, it's about the component parts and the supply chain. And those integrated supply chains have big impacts in the context of both importing of goods, exporting of goods, international supply chain, and also elements around rules of origin and what the original origin of the actual imported and exported goods are. So in terms of surveys on Brexit, there's been a number of surveys taken in terms of the big concerns that businesses have on Brexit, and this is a slide that the Institute were involved in one of our Belfast summits. So this indicates that some of the big top five concerns are tariffs on imports and exports. Again, that's an area that we have received questions on, which we'll be happy to refer to during the course of this webinar. Customs costs, the additional costs of doing business if and when the UK leaves the customs union, and possible delays at the border as well, and possible delays in getting to the border. The UK being blocked out of the UK EU market for product standards, so elements such as the CE mark and other directives and regulations could be an impact for some business. So the UK will be considered a third country when it leaves the European Union. So in terms of regulatory compliance, restrictions, product standards, that definition of a third country could have an impact. Clearly, availability of labour, citizens' rights is a key issue for a number of businesses and a high number of sectors. And again, that's an area we've had a question on that we will refer to during the course of this call today. So it is fair to say businesses do have an opportunity now to take advantage of a UK government grant scheme. So the UK government has announced £2 million worth of new grant funding to help companies train. The emphasis is around completing customs declarations, but there's an opportunity for businesses to understand why customs declarations are required, whose responsibility it is for declarations, and what the process is around it. The Institute provide a number of courses around customs procedures, customs declarations, even Brexit health checks and public Brexit courses, which are eligible for grant funding. You can see a link on here, and there's a link on the Institute website that provides a grant scheme. It's important that businesses take advantage of this. It's been put in place for very much for small businesses, mid-sized businesses, to actually use the grant scheme. And even if your freight forwarder or your customs agent makes the declaration for you, and clearly post-Brexit, as I will refer to, there could be a big increase in the number of customs declarations. You, as the business, are responsible for customs declarations, not your agent or your forwarder making the declarations on your behalf. So it's very important for companies to learn more about the grant scheme. There is grants available up to £1,050 per employee, and for businesses less than 50 employees, it's 70% off the cost of training reduction, and for businesses between 50 to 250 employees, it's 60%, and for businesses thereafter, it's 50%. So do look at a grant scheme. Do take advantage while you can of this grant scheme. It is due to finish on the 5th of April. So the Institute have also been involved in development of customs qualifications. So we have a few customs qualifications, but we've introduced some new ones. One, as you can see on screen, is a Customs Practitioner Award. So this is important for people be involved in customs processes, and the qualification on screen, the Level 3 Customs Practitioner Award, is linked with 4 face-to-face days training and then a multiple choice assessment at completion of it, and the cost is on screen there. Again, there is a possibility that can be linked to the grant scheme and for the courses that are noted there. So again, very, very important for businesses to invest. One of the opportunities for Brexit, and there must be, obviously clearly they can be seen as downsides, is that businesses now have the opportunity to invest for the future, to build their businesses into trading businesses that have worked internationally and can work around the world. And by investing now and taking advantage of the opportunity, you're making an investment for the future. So we've looked at Level 3 Customs Practitioner Award. There's also a Level 4 Customs Practitioner Award. That has 2 additional days training and covers elements such as export licensing and excise duties. So for businesses that are involved in excise, such as oils and alcohol, for example, it could be very important to learn about excise duties and procedures as well. Those businesses that are involved in export licensing requirements, both military goods and goods which have a dual use, that have a military and a civilian purpose, the export licensing element could be very important as well. So again, that's an important qualification as well as a Level 3 for businesses to consider and individuals to consider as well. Now, the Institute has had a qualification for a few years now, a Diploma in World Customs Compliance and Regulations. And this was introduced following working with industry and a number of companies and a number of organisations, including HMRC. And this is probably aimed at people with some experience of customs procedures. So that could be customs managers, shipping managers, freight forwarding companies, and trade compliance as well. So this is a qualification that has had a high number of students who have had a certain level of industry experience, perhaps 5 years experience in industry, or possibly have a legal degree or a tax degree, and are looking to get involved in this as well. So obviously we wanted to refer to a concept that some of you may be you may be aware of on the webinar, Authorised Economic Operating Status, AEO. It is an area for some companies that is a Brexit solution, and it has elements around both customs simplification and safety and security. It is a specialist area, and if anybody has any further inquiries on it, we'd be very much happy to take those inquiries, but also explain whether AEO is relevant to your business. It is important to mention that AEO has to be relevant to your business. It could be a Brexit solution, depending obviously what happens during the next couple of weeks. The Institute do provide consultancy services. We have taken companies through AEO and are doing so currently. And we also provide public training courses on AEO. And that could be important for companies to decide whether AEO is for their business, and also what the benefits are of AEO and what is involved in the AEO training process. So again, anyone has any inquiries, do please feel to raise them. We also have information on our website. Okay, so final slide in this section is just gives a summary of what's provided by the Institute of Export in terms of our training provision, our professional qualifications. I've referred to some of them today. We have events, a number of summits at around the United Kingdom, and details are available on the website, and forthcoming summits. And we also provide for our members helpline support as well. So that's very important, and obviously we have a good number of questions arising at the moment. And obviously we have open2export.com, which William has referred to. Okay, thank you very much.
Great, thank you, Kevin, for a very good overview there, and also for setting out how the Institute of Exports helps with many of these issues. So yeah, we're now going to open the floor for questions, and you can ask questions using the control panel to the right-hand side of your screen. The first one we have was sent in advance is from Catherine, and she asks, where do we stand in regard to the export of services and how invoices to customers within the EU may need to be changed? Over to you, Kevin.
Thank you very much indeed for the question. It's a good question. So first of all, I'll start with the export of services, because I appreciate on this call we will have companies that export services as well as goods. So there are a number of factors that service sector customers have to consider. And even if you're exporting goods, some of you may have services bringing goods into design, which have service sector impacts as well. In terms of the withdrawal agreement and political declaration, which has been negotiated with the European Union, which still has to pass through Parliament if it is approved. Probably little is said on the export of services other than to say that the United Kingdom and European Union intend to have a comprehensive and flexible arrangement for trade in services. In reality, there's a couple of things to mention for services. Now, the fallback position in the event of a no-deal Brexit is that there is a WTO General Agreement on Trade in Services, GATS. So again, I'd ask you to refer to that. That does refer to the fact that it allows member states of the WTO, which again, I appreciate I might need to explain further if we have questions on that. 164 member countries of the WTO have signed up to the fact that there is movement of trade in services, which basically allows businesses to sell their services into another country. So also to sell to consumers in other countries, and also the right to open legal entities and provide services in other countries for WTO members. There is, however, an exemption or an exclusion clause within the WTO that, if potentially indicates that a service is deemed to be harmful or against local requirements in the country concerned, that it could be not allowed to sold in the country. So clearly the United Kingdom would be looking for a more comprehensive element and, if you like, removal of that exclusioning clause. Now, some factors that services need to consider, and even goods to some extent, is if you're selling to consumers. So if you are providing services to consumers, then you obviously need to be aware of regulations and consumer protection. So there's things like the unfair contract terms, there's elements such as market services regulations, even regulations around digital services as well. Now, the UK has indicated it is looking to take EU law and EU regulations into UK law. Now, that has been put, and it has, I believe, been passed by the House of Lords, subject to some elements. However, legislation has still to fully pass through Parliament to take those regulations into UK law. So clearly there is a slight risk that legislation may not be passed in time, depending obviously on the outcomes of the next few weeks there. But the intention is to take EU regulations on consumer protection, market directives, distance selling into account. So UK companies will be liable in a similar way as they are today. Data protection. So if you as a service company or even a goods company are holding data on personal data, you need to consider whether you have standard contractual clauses in your contracts or your agreements which are very explicit and clear to the consumer in the European Union. What you don't want to do is breach data protection laws there. So if you don't have those standard contractual clauses, you may need to review them. Now, as we speak, the UK and the European Union have agreed adequacy around mutual recognition of GDPR standards. However, there is a slight discussion taking place as to whether the UK can continue to access data protection boards. And whilst those discussions and agreements are being reached, there's still some uncertainty about whether that adequacy agreement would be in time for when the UK leaves the European Union. So companies need to consider the amount of personal data they're holding on EU, whether their contractual clauses are very clear and explicit, and the EU consumer has agreed for you to hold personal data such as bank accounts, addresses, emails, date of births, etc. So those are some of the factors to consider. There is elements in terms of some sectors like software around talent attraction, and citizens' rights, which I'm sure we will refer to on this webinar, that specific businesses must consider if you have EU nationals working for you who are providing key services such as software, digital technology, for example. With regard to the question on invoices to customers, so invoice is an interesting one. It affects all businesses, obviously not just trading services. So there is clearly a risk if the EU and if and when the UK leaves the European Union, that contracts may be subject to more disputes. So if goods get delayed, if services are not delivered or regulations are breached, that there could be more disputes taking place. And if contracts do not have a dispute resolution arbitration clause on it, there is a risk, obviously, that contracts may need to be subject to legal advice, both from the UK side and the European side. So businesses should review their contracts and possible use of dispute resolution arbitration clauses. Equally, companies should look at if the arbitration dispute resolution is the European Court of Justice, the ECJ. They need to consider that and whether that is a viable dispute resolution arbitration area going forward. So those are some of the things to think of in terms of contracts. Payment terms are clearly important for all sectors, including the service sector. Is when am I due the money? Will the money take longer, and what is the payment and settlement system used as well? So those are some of the factors to consider. There are more in the service sector, depending on the specific type of service being exported or provided. Thank you.
Thank you, Kevin. And moving on from services to goods, we had a couple of questions in from Toby, and he's asked, in the event of a no deal, WTO tariffs would apply. Where can you look up tariffs by commodity code in that scenario?
Okay, so if you want to see what tariffs could apply, then effectively you've got a couple of options. So currently there's an EU market access database, and obviously we can provide a link to it if required, which tells you what the import tariffs are applied by the European Union. So if you are an exporter of goods, effectively depending which Incoterm is used, and we'll be speaking about Incoterms later, because I believe we've had some questions there. Out of 11 of the 12 Incoterms, the import tariff or the import duty will be paid by your European buyer. So therefore, there's a cost there, and you can see the EU tariffs, if you like, the EU WTO tariff, the World Trade Organization tariff, that applies to exports from third countries. So that's the EU market database. So if you have your product code, you can put it in and it will tell you what the tariff is. If you do not know your product code and you haven't had a need to find one out, then you would filter it by family tree. So for example, you'd put in something like cheese, steel, car axles or something like that, and effectively you can then filter it to the actual type of product you have. With regard to, we've had a question, I believe, later on, apologies if I'm going on the questions, for tariffs for third countries to the rest of the world. So I am probably getting ahead of myself a little bit. What happens there is the WTO, the World Trade Organization, has a website that you can filter by country and by product that tells you the import tariff for countries from the rest of the world there. So that's hopefully answered the question on tariffs. The EU market access database is very important to know from a European Union side, and the WTO, the World Trade Organization tariff, is very important from the rest of the world side.
Thank you, Kevin. And you mentioned Incoterms. We have had a couple of questions in regarding Incoterms. One is, if a business is based or is using Xworks, do they still need to provide customs declarations?
It's a very good question, thank you. So if you have a UK exporter is selling on Xworks terms, Xworks is the one Incoterm where customs declarations do not need to be provided by the exporter. They will be provided by the overseas buyer. And certainly Xworks can apply if you're selling to large multiple organizations, large retailers, large automotive companies or pharmaceutical companies, for example, because they have the logistics infrastructure, the volume to negotiate with the shipping companies and the freight forwarders. So that is fine. However, there are a couple of considerations that businesses need to make. And we have heard instances where even large retailers and large multiples, large manufacturing engineering companies are asking questions of their UK buyers, possibly thinking about moving to another Incoterm, FCA, free carrier alongside. Now, under FCA, the goods can still be collected from the overseas exporter's premises, but the exporter in that case is responsible for loading the goods on board the lorry, for example, and they are responsible for customs declarations. So whilst some companies might think Xworks is the solution, it is very important to try and make sure that you will be able to continue to use Xworks, because in some cases European buyers will be concerned that any delays at the UK border effectively could harm them, and they would want those delays to be the problem, if you like, or the issue for the UK exporter. One way of considering Xworks also is if the overseas buyer is having to make the UK declaration, customs declaration, that would happen more potentially where that European buyer has a legal entity and staff in the United Kingdom. So they have the resource and the expertise of UK customs procedures. So a couple of factors to consider. They're absolutely correct in the point on Xworks, but we do say to businesses, do be careful if your overseas buyer starts to look to renegotiate your Incoterms. Thank you.
Thank you, Kevin. And just while we're on the topic of Incoterms, Daniel's asked, if a shipment is made on DAP Incoterms, but the delivered place is not a port or border, how will the tariff payment communicated and paid between freight forwarder and consignee work?
Okay, so if DAP terms are used by the UK exporter, then clearly again the overseas buyer is responsible for customs declarations and is responsible for any duties that apply as well. The best thing we can say in those instances is obviously speak with your freight forwarder. Speaking with your freight forwarder is one of the key actions that all businesses should take right now. It's probably one of the first actions that need to be taken, and obviously discuss the individual circumstances, because it's fair to say that freight forwarders, or a lot of freight forwarders, have developed Brexit contingency plans, and they are looking at the end-to-end solution as well. There in terms of getting the goods to the consignee, and obviously getting the goods to certain locations. So yeah, it is very important there if delivery at place is used to have a communication with your freight forwarder, who probably will obviously link both transactions there. Thank you.
Thank you, Kevin. And we've had a couple of people asking about what happens in a scenario where shipments to or from the UK shipped before the 29th of March, but they arrive after the date. How are they treated, EU or third country?
Yeah, really good question there again. Let's take a third country, because clearly some of the sailings for the third country have already left now before the 29th of March, and it is a question. So with third countries, I guess a couple of things to consider here. One, if the vessel has left and the bill of lading has been produced, and if you like, proof of shipment is provided, that does clearly put it into a stronger position. There is an element to consider, additional element, that if your goods are transshipped, so for example, they're moving through Rotterdam, or Antwerp onto Asia or the Middle East, for example, that it's worth making your clear with the freight forwarder there on the actual position and the securing of slots. But clearly the issuance of the likes of the bill of lading and proof of shipment are very, very important in that consideration. However, perhaps even more important is to check, obviously depending on the Incoterms used, but to actually check, get your overseas buyer to actually check with their customs authority, to actually see whether their customs authority will clear the goods. Now that's important, obviously. I know we have a question possibly raised in terms of third country tariffs or agreements for free trade agreements the European Union has with third countries, but that would be particularly applicable. Examples would be Japan, for example, South Korea, where obviously tariffs could be applied. So the best thing to do there is to get your overseas buyer to actually check with their customs authority to make sure the goods will be cleared. Obviously, if a bill of lading is provided, and depending on your payment terms, it may need to be a non-negotiable copy bill of lading that provides evidence and proof of shipment. So that's probably a big factor to consider there. Now, with regard to the European Union, where clearly transit times are a lot shorter than trade with the rest of the world, that's an interesting scenario, I guess, if you're shipping, for example, on the 27th or the 28th of March, depending obviously on what happens in the next couple of weeks. Again, similar arrangements, right? Speak to your freight forwarder, check this issue with them, get your European buyer to actually speak to the relevant European customs authority as well. What we do not want is goods to be held up. So it's very important to communicate there to avoid any issues in that respect. Okay, thank you.
Excellent, thank you, Gavin. A question we've had from Gemma, who exports particularly Class 1 medical devices, but we'll ask this generally. For products with CE marking, what advice have you got about selling UK manufactured products into Europe after 29th March?
Okay, again, thank you for the question. It's a very good one. So certainly medical devices, there are a number of things to consider. So clearly in terms of the MDR, the Medical Directives Regulation, there are a few things to consider there, and there's a few issues concerning medical devices, and it might depend on the actual type of medical device concerned. So I will speak about CE mark shortly. I do suggest that's a question with a bit more information required in terms of the actual type of medical device, and we can provide obviously attempt to provide feedback. Now, with the CE mark in general, this is an interesting one. So one element of potentially being a third country outside the European Union is currently EU member states, companies in the EU member states can have notifying bodies, or in some products they can self-certify. The principle is that if a country is a third country outside the European Union, that effectively companies and notifying bodies will not be able to certify. The organisation must be within an EU member state. Now, the UK is looking to create a UK CA mark. The question is will it be in time for the 29th of March? That is a question mark. And also it has to receive mutual recognition. So businesses certainly cannot rely on that UK CE mark being agreed in time. Clearly, given time, such as a transition period or an extension of Article 50, it may be build some time to create mutual recognition of the UK CA mark. One solution, or solutions that are being considered by companies, is to use agents in Europe to, and if you have multiple products and multiple buyers, it's possible, obviously, for that CE mark to be done by an agent. We would strongly suggest, with regard to agents, there is an EU Commercial Agents Directive that you need to be a little bit careful of. So before you appoint an agent, we strongly suggest that you consult with the EU Commercial Agents Directive, because it's not easy to extract yourself from an agent's relationship. Another thing is to get the foreign buyer to undertake the CE marking, but if they do, they may obviously want to pay for it. And the final thing, obviously, is if you, some companies have created legal entities in EU member states so they can self-certify or use an EU notifying body. That has been a solution for some companies. Okay, so thank you very much. Good question there.
Cool, thank you. We've had a couple of questions from food and drink exporters, and we do have a lot of food and drink companies on the call today. One has asked, if there's a no-deal Brexit, is there a list of countries to which exporters of food and drink products would need to make changes to packaging? And there's also a question more generally about tariffs in the food and drink industry again as well, and where you can find out information on those.
Okay, thank you very much. Again, a good question, because food and drink is a sector clearly where packaging and labelling is quite stringent, as are tariffs, and unfortunately food and drink products are amongst the highest tariff goods locally. So a few things in terms of packaging and labelling requirements. Obviously, for countries outside the world, the EU market access database I referred to earlier has information on what's called non-tariff barriers, which includes packaging, labelling and regulation, as does the WTO site as well. And the UK will also hopefully be producing a non-tariff barrier database as well. With regard to the European Union, that is an issue in that the EU is there could be differences in packaging requirements post Brexit or post the 29th of March. Again, we can provide a link. There has been some government technical notices on changes to food packaging in the extent of a no-deal Brexit. So again, we can provide the link for that information there to assist you. And it is important you look at that notice. It is always difficult with government notices because they can obviously be lots of information, but they are there to help you. Just on a side point there, we would recommend that every company signs up for a link to a HMRC link and the Department for Exit in the EU. That could be very, very important in terms of making sure you get alerts there, especially alerts relevant to your sector. Now, with regard to tariffs, so having said obviously food and drink products are amongst the highest tariffs, that's absolutely correct. Obviously it depends on the nature of the product. So clearly things that are related to animals and animal byproducts, dairy products, for example, they are unfortunately quite highly tariffed there. So to find details of tariffs, again, you can go on the EU Market Access Database. In the event, obviously, of no deal and tariffs being applicable for imports into the European Union, and in the rest of the world, you can go to the WTO site. there. Now, it's fair to say at this time that the UK has not announced what its tariffs would be in the event of a no-deal Brexit. There has been a lot of press speculation in the last couple of days, and whether those announcements will be made before the big votes in Parliament next week will be an interesting one. So companies should keep looking out for that as to what the import tariffs in the United Kingdom could be in the event of a no-deal Brexit. But yeah, so interesting there, but we would encourage companies in the food and drink sector to actually check what their tariff could be. Now, there are potential ways of deferring duty, only deferring, not eliminating it, around HMRC duty deferment guarantees. That's for importers. Thank you very much.
Cool, thank you, Kevin. And we've had a few questions in, just generally speaking, around residents' rights, citizens' rights in the effect of a no deal. Obviously, a lot of people aren't necessarily UK residents at the moment. So can you say a little bit around citizens' rights and how they might be affected as well, please?
Yes, so in terms of citizens' rights, there's a few things for businesses to consider there, and I guess individuals to consider as well as businesses. So the government has announced that up to probably the middle of 2021, that any EU nationals that have lived in the United Kingdom for more than 5 years can apply for UK citizenship. There is information on how to apply for UK citizenship and a form to complete. So anyone who has been, and generally to meet the citizenship requirements, obviously there's individual personal information required. We would need to have been in the UK for at least 6 months for each of those 5 years. Now, if you've not been in the UK for 5 years, so less than 5 years, for example, 1 year plus, you can apply for pre-settled status. It doesn't guarantee you settled status at the end of the 5 years, but it gets you into the system, so to speak. So that's one element for citizens' rights, and certainly businesses may want to consider what their profile of EU nationals working for them are, and whether they want to encourage and support their EU nationals to apply for UK citizenship or for pre-settled status if they don't meet the 5-year criteria. Now, with regard to what happens in the event of a no-deal Brexit, the UK government has put forward an immigration bill, but it's not been approved by Parliament yet, and it will clearly have to go through some potential readings. What that is indicating, and I do stress it has not gone through Parliament or been approved by Parliament, is the Migration Advisory Committee have recommended that the cap for the definition of skilled workers threshold is £30,000. Now, the general perception is, and I do say perception, if you earn over £30,000 as you are defined as skilled, you will be more welcomed into the United Kingdom, and the requirements to live and work here will be, if you like, less demanding. For that's not the correct term, but for want of a better word. Now, if you are earn less than £30,000, the immigration bill is suggesting that you will have to apply for a 12-month visa to live and work in the United Kingdom. After those 12 months, then effectively you will have to go back home, and you will not be able to reapply for another 12 months. So that's with regard to UK citizenship. The other side of that is if you're a company that has overseas employees, so you have a UK national based in Europe, the EU has agreed to reciprocate what is agreed in the United Kingdom. And there were some interesting statistics today in the Times newspaper around the number of citizens, UK citizens, that have applied for EU citizenship. So there's been a massive increase in various countries, Germany in particular, in terms of UK nationals applying for EU citizenship. Other countries clearly being the likes of Ireland. So that was an interesting article in terms of the surge there. Thank you.
Thank you, Kevin. And a question from Marie is, what will happen if you have a REACH registration in the EU? Will you need a new one for the UK?
That's a really good question. So REACH obviously applicable to chemicals. It's actually a question I'll be working on for a piece of work I've got in a couple of weeks. So you're a little bit early in terms of the question. In terms of licenses and REACH, probably what I'll do is if it's a very good question. If you could post that question and provide the details, I will probably come back to that question further to you. With some elements around these international committees, I just need to check, if you like, where the UK sits in terms of globally, in terms of its REACH access, and how that links in separately. Because in some instances, the UK is part of international conventions, of obviously which REACH is, and in some instances it's part separately, and in some instances part of the European Union. So if I could ask that question, I will be doing some work on REACH. I will come back to REACH on that.
Thank you, Kevin. And just on the kind of general topic of licenses, we've had a few questions around licenses and export controls. What advice would you do for companies uncertain about what to do where licenses and controls are concerned?
Okay, so it's very important, I think, to consult with the ECJU, the Export Control Joint Unit, which used to be called the ECO, the Export Controls Office. The government has issued a paper, I believe it was in February, around the fact that open general export licenses will be required in the event of a post-deal Brexit. And it has, I believe, indicated what the application process will look like. So again, we can make that available to you so you can see it. You may have seen it already. Clearly, there may be some uncertainty in terms of how long it will take to apply for the license. Will there be an area there that you can apply, and can you store it up, if you like, ready to be used on the 29th of March? But like all export licenses, it's very, very clear. You need to be very clear whether license is required, and if any doubt, contact the Export Control Joint Unit, the ECJU. But the general principle is, in the event of the UK leaving the European Union, that new open general export licenses will be required. Thank you.
Thank you, Kevin. And we've had a question in from Lynn regarding sanctions and exporting to the EU. Lynn's heard that companies may have to register with the Home Office and DIT. Would you like to expand just in general around how sanctions might be affected?
Okay, yeah, so obviously international sanctions, economic and financial sanctions, can be applied at the United Nations level by the UN Security Council, and companies also need to be aware they can be applied by the United States Office for Foreign Asset Controls, which can be quite rigid, and UK companies, especially with UK bank accounts, need to be very, very much aware of potential issues there. So clearly some companies that are not subject to UN sanctions, such as Syria, are subject to United States sanctions. So, and also some Russian organizations subject to sanctions, and Cuba and various countries there. So it's very, very important there to be aware of the US Office for Foreign Asset Controls as much as the European Union. Now, the EU has sanctions in place, and I think what the UK has indicated is that it will mirror those sanctions in the event of a no-deal Brexit. So it's very, very important that the UK would not want to, if you like, fall foul of sanctions, both in terms of the United States as much as the European Union. So again, be very much aware of the sanctions environment, be aware of obviously the penalties for sanctions that could arise. And like a lot of things, if you are dealing with countries that could be subject to sanctions, and products that are subject to sanctions, it is very much worth making certain organizations aware of that. So again, possibly the Export Control Joint Use for end user requirements. Your bank will obviously take an interest in it as well, and they have obligations in terms of making sure that transactions are not subject to sanctions. And obviously worth contacting HMRC and the Department for International Trade as well. With regard to the authorization process, I think it's fair to say the best advice is to make sure you contact and make sure everyone aware of the sanctions process that could arise. Obviously, you will be aware of the countries that you're dealing with there. It's fair to say that the UK will take a very strong approach to sanctions in the same way as the EU, the United States and the United Nations will.
Thank you, Kevin. And we had a question in from Colin, who's asked, Well, he said that we understand the AEO authorizations issued by the UK may not be valid in the EU. What is the basis for this, and what sort of mutual recognition will there be for AEO? Do we know at this stage?
Yeah, it's a really good question. Very good question. Again, it would be a cliff edge scenario if the UK, if the EU did not recognise UK sanctions. The general feeling has been is that mutual recognition will take place. I guess you could argue it's a bit like the GDPR issue, is that the issue is so big that the implications of it could be very, very serious. So it's not to say it won't happen, because there's always definitely a risk there. But certainly the intention is that UK AEOs will be mutually recognised in a similar way that EU AEOs will be mutually recognised in the United Kingdom. The EU has a number of mutual recognition schemes for AEO with the likes of United States, China, Japan, Norway, for example. So it does have this concept of mutually recognising AEO schemes. And it's fair to say that, like GDPR, the UK has been heavily involved in implementation of the schemes. Clearly, AEO is a wider topic for businesses to consider as to whether it's a benefit for the business. And again, it's something we can speak on an individual basis to individual companies. I appreciate some people on the call will be less familiar with authorised economic operator. If you're working in some sectors, clearly authorised economic operator is more likely to apply. So if you are a freight forwarder, for example, involved in customs clearance, if you're working in the oil and gas sector, the aviation sector, advanced engineering, manufacturing, possibly pharmaceutical sector as well, AEO is more likely to apply. That doesn't mean that AEO will not apply for certain sectors. So bottling companies, for wine companies, are under pressure to become AEO from the major wine exporters of the world. So again, it's a separate discussion, a separate conversation with regard to authorised economic operator. We would sincerely hope that a mutual recognition will be agreed. Again, through the Institute and for Open to Export, we will keep people advised in that respect. Thank you.
Great. We've had a few questions again regarding VAT, and we did do a webinar on Brexit and VAT quite recently, but could you do just a quick recap on kind of how VAT may or may not be affected at this stage?
Yeah, that's okay. Yeah, so again, VAT, I guess it's fair to say that some of the final rules are still to be, like a lot of things, could be impacted in a post-Brexit scenario. So clearly, in the event of the UK leaving the European Union on the 29th of March, there could be wider aspects there in terms of VAT, so watch out for. At a high level, what is likely to apply, and I do stress likely at the moment because there's lots of scenarios here, is the treatment of VAT will change. So currently, for example, if you're selling services on a VAT business-to-business basis, post-Brexit, the way VAT accounted is changes. So, for example, you won't have to obtain a valid VAT number, and you won't have to record it in terms of EU VAT reverse charge mechanisms. So the way is changing. The actual provision of providing your valid VAT number is less of a requirement. There are some nuances around VAT, and one of them is triangulation. So if you are providing a service whereby you are providing a service, let's say you're a UK company and you're providing a service and it's going from, say, France to Belgium, you will need to register for VAT in a European Union member state to offer that triangulation service. There are also specific nuances around the MOS system, which some of you may be familiar, the mini one-stop shop. So if you have multiple online selling and use of VAT, you again may need to register in an EU member state, or unfortunately, potentially in each EU member state services are provided. So again, William obviously quite correctly referred to a previous webinar we provided. If there are specific VAT questions, you're obviously welcome to send them in. What I would stress as well is VAT is an interesting area that the Institute has established a new course on VAT, because we are getting a lot more questions and it is quite a specialist area. So I do believe we have a course on the 18th of March on VAT. So if anyone is heavily involved in VAT, whether that's through online selling, through provision of services and triangulation, do look up that course on the 18th of March because it could be very, very useful for you. Thank you.
Thank you, Kevin. And another question we just had in, and it kind of relates to another big topic. So Peter has asked, in regard to trademarks, will existing trademarks still be valid within the EU after 29th March? Will companies need to register them again? And I guess in general, kind of how will intellectual property be affected?
Okay, thank you for the question. Yeah, okay, there's some relatively good news on intellectual property. There is a but in here, but there's relatively good news. Okay, so first of all, in terms of patents, the European Patent Office is not an EU organisation, so likes of Turkey, Serbia, for example, have access to it. So if you have already a patent or a trademark in the European Union, that will still apply in a post-Brexit scenario. You don't need to re-register. So that's good news. There are a few things to bear in mind. In the event of the UK leaving the European Union and you want to register your patent, you would need, or trademark, you would need to register it in 2 jurisdictions potentially, especially for trademarks. So you would need to register it in the United Kingdom separately, and you would need to register it in the European Union or as well. There. So that's one consideration. So there's additional costs and obviously 2 application forms. One good site to look at is the UK Intellectual Property Office, IPO, in Cardiff, have produced some good information in that respect that you can refer to. If you take enforcement action around your intellectual property in a post-Brexit scenario, you would have to take enforcement action in the EU and in the UK separately. A final thing to mention, and clearly a number of companies are putting forward now patent applications as we run towards, proverbially speaking, the 29th of March, is if in the event of a transition period, I think it's been agreed, and this may change if the withdrawal agreement changes and political declaration, that companies have 9 months before the end of a transition period, if there is one, to register their IP in one jurisdiction, and the UK would be part of that. So that's something to bear in mind if you have patents and trademarks prior to the end of the transition period. Thank you.
Thank you, Kevin. And yeah, we're starting to get into the last couple or 2 or 3 questions now. We had one from John, which sums up a question a few people have asked, which you may have alluded to earlier, but it might be worth recapping. So he asks, even if the withdrawal agreement is voted through Parliament and the UK enters a transition period on 30th of March, is it correct that the currently existing FTAs which the EU has in place may not automatically be rolled over for the UK? And I guess in that topic, could you talk a little bit generally about the FTAs we have with countries outside of the EU through the EU at the moment?
Okay, thank you. Yeah, so just taking parts of those questions. If the UK enters a transition period, it remains part of the single market and the customs union. So some of the areas in terms of tariffs, customs declarations, etc., to some extent it's business as usual. However, businesses need to prepare. We obviously know the situation potentially currently and the rush to prepare. So businesses, if we enter a transition period, must use that time to prepare. They cannot sit back and think we've got 19 months or longer, because what we don't want is a situation in a year's time where we got now. So very important for businesses to use that. Now, with regard to trade agreements as a whole, the European Union has agreements with 74 countries, and there is an EU database, a website which gives you details of what each agreement is. Now, some of those agreements are more comprehensive trade agreements, so the likes of Canada, Japan, South Korea, Turkey, Norway, Switzerland, for example. And they are good. They are help businesses. So if we enter a transition period, the likelihood is, and I do stress the likelihood is, the UK will still be able to continue to access those EU trade agreements because we're part of a single market. That raises questions as to whether the UK can negotiate separate trade agreements, and obviously different politicians, ranging from Donald Trump to Theresa May, have voiced their opinions on whether we can or we cannot. There, and the United States-UK trade agreement, again, is one that's received press. The general theory is that the UK will not be able to negotiate trade agreements if it's in a transition period. Doesn't mean it can't have discussions, but actually formally sign them, perhaps less so. But again, different people have different views on that. Now, with regards to trade agreements in general, if the UK were to leave with a no deal, whenever that is, it will lose access to overseas trade agreements that the EU has. Bear in mind that these trade agreements are not all free trade agreements. There are some alliance association agreements as well, and the EU website gives details of what that agreement covers. So the UK is trying to roll over its trade agreements, and there is a ukgov.uk website with the status of where the UK is currently in that respect. So if the UK is successful in rolling over the trade agreement and also conformity compliance agreements with some countries as well, such as on veterinary certification and medical certification, for example, then that's important there. What will be important there is the UK is that companies will need to produce a UK certificate of origin, indicating that 60% of the goods are of UK origin. So again, hence the supply chains and origin requirements I referred to earlier are important. So general principle is for companies, look out on these trade agreements, look at the situation. There has been commentary in the press that the likes of Japan and Turkey have indicated that they will not have this trade agreement signed by the 29th of March. Again, that obviously presupposes what is going to happen in the next couple of weeks. Thank you very much.
Great, we'll do one last question, and it comes from Carol, and she's asked about kind of re-exports, so products that you're exporting again, having maybe repaired them or done something to them upon them coming back to you. What happens with re-exported exports in the case of a no deal?
Yeah, so in the case of a no deal, it could be that your company and other companies are obviously used to dealing with repairs and inward processing, outward processing for trade outside the European Union already. However, if you're not, the potential in the event of a no deal is that inward processing, outward processing requirements will be required and return goods relief for trade between the UK and the European Union. So if your business does not have access to inward processing, outward processing, if you like, call them custom special procedures or returns good relief, they should think about applying right now for that in the event of a no deal Brexit. Now, sometimes a guarantee may be required from your bank for use of these services, but there is a possibility you fill out a customs questionnaire that one might not be required. It depends on the nature, the value, the volume, how the goods are stored, etc. So again, the general principle is if the UK leaves the European Union, that the likes of inward processing, return goods, etc., will apply. So companies need to apply for relief schemes. They need to be aware of the possibility of a possible bank guarantee required, but equally they need to fill out the customs questionnaire first. Thank you.
Well, yeah, thank you. We can now you can now breathe, Kevin. That was fantastic. Fantastic answers to a lot of questions, and we've had plenty more come through. And as Kevin has said, if you didn't get to your question, please do send it to us at admin@opentoexport.com. We'll try and answer where we can, and in some cases we may refer you to our technical helpline as well. But yeah, thank you so much, Kevin. That was really helpful. Great. So if you need more detailed information and support in preparing for Brexit, the Institute of Export and International Trade is continuing to run several training courses around Brexit and export processes in general. Among these are the post-Brexit planning workshops and Brexit health check services we provide. You can also apply for government funding from many of our customs-related courses. This funding is designed to help businesses who are or will be required to make customs declarations in the near future, something which will obviously become a big thing in the event of a no deal Brexit. Links to all these services and courses can be found at export.org.uk/training. We've also got a World Trade Summit coming up in Manchester next week. This is a great opportunity for exporters in the Northwest region to network and learn from fellow exporters and trade specialists in the Northwest region. You can find sign-up details to this event at export.org.uk/events. We held the final for our 10th Export Action Plan competition in London yesterday, with Age Check Certification Services Limited winning. The 11th competition is now open for entries as well, and you have until April 12th to enter that. It's a great chance to win £3,000 cash towards your export plans, and goodness knows, I think we'll all need to have good export plans in the near future. Our next webinar will tackle currency on March 20th, with BB Financial Services speaking. Sign-up details for all of our webinars can be found at opentoexport.com/webinars, and also circulate the registration details for this webinar in the aftermath of this session. And we'll also send a recording of this webinar to everyone who registered to this webinar today in the aftermath as well. As always, please do take our exit survey to let us know what you thought of today's session and to give any suggestions for improvements or future topics. But for now, thank you very much.